Hello, everyone. Welcome to Sakshi TV's special immigration talk show with attorney. I'm Preeti Mulbagal, your host for the show. The topic of discussion today is the new rule proposed by the Department of Homeland Security that could significantly reshape the F1 visa program for the international students in the United States. For decades, the F1 visa pathway has served as a gateway for talented students around the world to pursue education, innovation, and opportunity in America. However, these new proposed reforms have sparked a widespread concern among students, universities, and immigration professionals, raising critical questions about compliance, accessibility, and the future of international education in the US. Today, we are fortunate to have an experienced attorney with us to break down these proposed changes and explain the legal implications and help students and families and institutions to better understand what may lie ahead. Let's welcome our today's guest, Ms. Saimithra Reddy, who has been gracing our show regularly and needs no introduction. Ms. Mitra, thank you for joining us today.
It's a pleasure to be here.
So, what is this new DHS proposed rule for the F1 visa program, and why is it considered one of the biggest shifts in international student policy in decades?
Like you just said, it is actually considered such a groundbreaking rule that is going to bring about a lot of changes for F1 students, not only those who are going to come in the future on an F1 student visa, but also those who are currently living in the United States on an F1 visa. There are so many different changes, including how the I-94 will be issued. Students will no longer be given a duration of their status, which means they can stay here as long as they maintain their F1 visa. Their grace period, which used to be 60 days, is now going to be shortened to 30 days. So after they're completed with their studies and working, they have only 30 days now to figure out what their next steps will be. So there are some really big shifts coming in this new rule that will be implemented within the next few months.
So, how does this proposal differ from the current duration of status system for F1 students?
So currently, any F1 student who comes to the United States on an F1 visa is admitted and given a document called I-94. On the I-94, for every other visa category besides F1 students, they are given an end date, which is essentially the expiry date for how long you can stay in the United States. For example, if you come on a tourist visa, they might give you up to 6 months of stay, and before the last date on your I-94, you have to leave the country. For F1 students, it's very different because until now, they have been given a duration of their status, meaning as long as the student is maintaining their status by either being enrolled in a full-time course of study or working through OPT, STEM OPT, CPT, right? As long as they're either studying or working, they can continue to stay here for decades and decades. There's no end date. So that is going to now shift under this new proposed rule. The Department of Homeland Security is going to start issuing I-94s with a maximum validity of 4 years. So a student who enters can only stay here for 4 years. And after that, they have to formally request USCIS to either extend their status or change to a different type of visa category.
So, what do you think has motivated the DHS to propose these changes now?
That's actually a really good question, and DHS has been very open about this. They say that they have looked into F1 student visas and different fraud that has been happening with these student visas. And there's currently over 2,000 students who have been admitted into the US from 2000 to 2010 on F1 status, and they are currently in the year 2026 still maintaining F1 status because they're using this duration of status as a loophole to continue enrolling into a program, maybe a second master's, third master's, PhD, and they're continuing to maintain that status. And now the DHS is saying, we want to prevent that from happening. We want to ensure that students come, study, work for a few years, and go back to their home country, which is what the F1 program is originally designed for.
What would the new extension of stay requirements mean for students whose academic programs exceed the initial visa period?
Right. So that is the really important distinction. If you are now only given 4 years of validity, and maybe you're coming here for a 5 year PhD program, you would have to request a formal extension by filing Form I-539 with USCIS and providing some sort of explanation as to why your status should be extended. In a case where the program itself, like a PhD program, goes beyond the 4 years, I can anticipate that USCIS will easily extend your status for another year so you can finish your study. However, the problem becomes when you have already finished your degree, say you come here for a 2 year master's degree, and then you want to stay and work on OPT, fine, that's another year. You can stay, but your STEM OPT period, which is traditionally given for 2 years, would be impacted. Students would no longer have the traditional 2 year period and they would have to request an extension. Most likely, they would have to show that they actually have a real job and their employer needs them to stay, right? So it becomes a lot more difficult to request that formal extension and get it approved.
Wow, that is so true. They've shortened the grace period after the program completion.
Mhm.
So, what about the status changes then? The students planning for OPT, STEM OPT, and what about the other status changes? So, is there something
Right.
called CPT which you can help with?
So, another major change that this policy is proposing is that students who come to the US, for example, for a master's level education, can no longer enroll into a second degree, which is of the same level of education. So students will no longer be able to enroll into a second master's degree if they are done with their OPT period and their STEM OPT period. Maybe their H-1B does not get picked in the lottery. They can no longer do a second master's. This will take a huge toll on a lot of students' ability to stay here, a lot of universities who assist students, and the only possibility would be for students to enroll in a higher level of education, like a PhD program.
So, there
Yeah.
are new restrictions on transferring schools, changing majors, or moving between degree levels.
Exactly. It's a little different depending on what level of education you come here to the United States to pursue. So, if you come for an undergraduate or bachelor's degree, you can change programs, but not within the first year of entering. So, you have to, if you come to study in Chicago, for example, you have to stay in that university in Chicago for 1 year and then you can transfer. For master's students, it's gotten a lot more strict, or it will get a lot more strict after this rule is finalized, in that if you come with an admission to one university, one program, you are not allowed to change until you complete that program. So that is very, very different from right now, where students may have to change a program for multiple reasons that no longer will be allowed. You have to finish whatever program you came here to start.
How could these changes increase the risk of falling out of status or for students?
I think right now it has been very easy for students to maintain their status. All you have to do to be in F1 status is, of course, not do anything that violates your status, but more generally, either be enrolled in classes and studying, or you have to be working with authorization through your OPT or STEM OPT employment authorization. So if you're doing one of those things, you're maintaining your status. Now, I think it would become a lot easier for students to fall out of status if they don't keep track of the date on their I-94. Maybe they have their STEM EAD card approved and they think they can just stay, but you still, the I-94 will be the most important date, regardless of when you have work authorization until, regardless of when your program end date, when your graduation date, all of those are secondary. Right now, it will be the most important thing to know when your I-94 end date is. So it's really important for students to keep track of that date. If not, they can fall out of status.
So, what are the potential consequences for students who miss extension deadlines or face administrative delays?
The consequences can be very severe. They would fall out of status. They could be placed into removal proceedings. That means you would have to go to immigration court and face an immigration judge. And the judge, if they find that you have violated your status or you are not maintaining your lawful status, they can order you for deportation and you could be deported back to your home country. So the consequences are very serious. Mhm.
Would these proposed changes affect current F1 visa holders immediately or only future applicants?
So this is still a bit of gray area. The rule is in the final stages. However, it has not been completely implemented yet. So we can see a few differences between what the rule is now and in a few months when the rule passes. However, as it stands now, current students who are in the US with an F1 visa will also be impacted in certain ways. For example, their I-94 may no longer be valid for a duration of their status. From when the rule is implemented, if it's implemented in September, from that date, students might be given a maximum limit on their stay in F1 status for 4 years. So this impacts
Mhm.
students who are here in the US as well. The shortening of the grace period from 60 days to 30 days, I don't believe that will impact current students, only new students who are coming after the rule is finalized and published.
So, how might this rule impact the dependents of F2 visas who are on F2 visas?
Yes, there definitely is a huge impact because an F2 dependent, a spouse, a child, anyone can only stay in the US legally as long as the F1 student is maintaining their lawful status. So if the F1 student falls out of status or they're approaching the end of their 4 year period, then the F2 dependent would potentially also face deportation or have to leave the country if there's no other alternative for the F1 student.
And coming to the institutional and economic impact, what challenges could US colleges and universities face if this rule is finalized?
I think in terms of economical impact, the most obvious thing is that a lot of students will, a lot of companies will not be hiring students, international foreign students, right? With only 1 year of OPT work authorization and potentially only 1 year of STEM OPT work authorization, companies will lose out on opportunity to attract this global talent from international countries. So a lot of students will not be able to secure jobs. Employers, of course, want someone who can be with them for longer periods of time. They don't hire someone for short term. So I think job loss and economic impact will definitely happen. And the universities, I think there will be a lot of confusion. There might be a lot of issues that the designated school official in every university has to also work with the students and make sure that they are maintaining their status and timely filing any requests for extension and supporting the students. So the universities also will be impacted because the rules are getting more complex.
And could these changes discourage international students from choosing the United States for higher education?
I believe so. I 100% think so. International students are choosing the United States because of the flexibility of being able to study and have work authorization after completing their graduate studies. A lot of other countries, for example, the UK, it's very difficult to get work authorization after you complete your studies. So in the US, this is such a big benefit that a lot of students come for not only to pursue studies, but to also be able to gain really valuable work experience related to your education. If you take that away, I can definitely see a lot of international students rethinking their interest or their ability to come to the US.
How might this affect the US competitiveness in attracting global talent?
I think it directly impacts, right? Because if students, like I mentioned earlier, are not able to stay here, if maybe their degree takes a little longer than what they initially anticipated to complete, they won't have work authorization for a long period,
Mhm,
maybe 1 year
mhm.
maximum. So this directly impacts employers' ability to hire foreign workers and limits the pool of talent in which they can hire workers. So this will have a huge negative impact.
Thousands or probably millions of students will be so disappointed if this comes into practice.
Yes, yes.
And coming to student preparation, what steps should current and prospective FN students take now to prepare
I
if
think
this rule
this
comes into
rule,
practice?
right? So it's not a question of if anymore, it's a question of when, right? So the rule was a proposed rule back in September, October last year, but now it is in the final stages. It's just going through some administrative review. Within the next 60 days, it will go into effect. Whether all of the components of this rule will go into effect or not, that's a question, but I highly anticipate that the I-94 is no longer going to have a duration of status. So it could be challenged by court cases in the future. However, this rule will go into effect, and students do need to, one, keep themselves educated on what changes are coming, right? How it impacts them, how it impacts their ability to maintain their legal status here. If you have any dependents, make plans accordingly for maybe sending your dependents back to the home country as you navigate the different changes. And also, if an extension is required, work with a lawyer, work with your university to make sure you're timely filing an extension so that you don't go out of status. So students need to be prepared. They need to keep themselves educated and know what's coming because this rule will be finalized soon.
So, how important will the immigration complaints documentation become under the proposed system?
Extremely important. It's no longer a matter of choice. Like I've been saying, the
Mhm.
I-94 end date is going to be very important. So if you don't
Mhm.
timely file this request to extend your status with USCIS and you don't properly file it, you will lose your status and you will have to leave the country or else risk living here in the United States illegally. Right. So it's extremely important that you comply with all of the documentation and immigration requirements.
Should students reconsider program length, school selection, or career planning based on these changes?
Absolutely. A lot of students, get an admission to a college initially, maybe a really good state college, and then they come here. Maybe after one semester or two semesters, they realize tuition is too expensive or the course is very difficult or for whatever reason, right? They may decide to just change to a different program. That is no longer going to be allowed. So you have to
Mm.
be very careful in selecting your program, your college, everything. If you come here and suddenly realize that, oh, tuition is too expensive or this place is too hard to live in, I don't have any support system, I don't have family or friends, there's some random state and I want to move, that's not going to be an option. So you have to stay there and finish your program or you have to leave. So I would advise students who are thinking of coming to the United States to very carefully think about where they're going to move, what their support system looks like. Can they financially afford to pay the tuition fees and all of those factors before just coming
Mm.
here for studies? Yeah.
Yeah, they need to make up their minds before they even start.
Yeah. Yes.
So
Yeah.
they do not have an option to do a trial and error method this time from now
Yeah.
on.
Yeah. Right. Right. Correct.
So, coming to the legal processes, where does this rule currently stand in the regulatory process?
Sure. So it is in the final process. I mean, rules generally they're proposed by DHS and they are published in the Federal Registrar where anyone, you or me, can look at the rule, read the rule, and there's usually a comment period for 90 days, 120 days. In that comment period, anyone can comment. And this rule also, when it was published last year, received, I believe, over 20 to 30,000 public comments, mostly in opposition because of how big of an impact it will have on students. This is not only applicable to F1 students, but also J1 candidates. A lot of J1 candidates come here for shorter periods of time for training, for example, for medical internships, right? So a lot of different types of students come here, and it will very negatively impact their ability to finish their education. So for that reason, there has been a lot of opposition. So the public comment period is now closed, and it is in a administrative review where it's just before a budget board essentially. DHS is in the final stages of taking all the comments into consideration and finalizing it. So it will be published within the next 60 days. We can anticipate it to go into effect by August of this year, so after the summer.
So, having
Mhm.
said that, is there still any room for legal challenges before the implementation?
There could be. I don't think they will be successful because you can't challenge something that's not a final publication yet, right? So if something is a
Mm.
final rule or a final law, then you can legally challenge it. It's a bit premature to challenge it now and say
Okay.
this shouldn't come into effect. Yeah. So any legal challenges I anticipate after it is published and finalized in August or September.
So, could future litigation delay or block this rule? Any possibility?
It potentially could, but I will be very honest. Even though it has a very negative impact on F1 students, the DHS authority to grant an I-94 for whatever period of validity they feel is apt is very strong. It's a very sound statutory policy that they're leaning on. So DHS and the Customs and Border Patrol officers at the border can authorize anyone to either enter the US or be sent back. And they can also say you're only allowed to stay in the United States for X period of time. So it is well within DHS's authority to say that we are no longer going to give duration of status, we're going to give 4-year increments. So even if there is a legal challenge, I highly doubt that this aspect of the rule will successfully be challenged, but other aspects may be. For example, shortening the grace period from 60 days to 30 days. That could be challenged and successfully.
So, what timeline should students and institutions realistically expect?
Yeah. I think
It
60
it will
days.
not go beyond.
Most likely, no. I think within the next 60 days it will be finalized.
So
Yeah.
it looks like there is no wiggle room here.
No, because this was proposed last year and open for a very long comment period, and now it's in the final stages.
So, what are the biggest misconceptions students currently have about this proposed rule?
I think students need to understand that it is still a proposed rule, right? So anything that you're seeing online outside of the actual rule published on the Department of Homeland Security's website, they're all speculations. Even a
Mhm.
lot of what we've talked about today, this is what I believe the rule says, but things could be changed. So if you are seeing anyone on social media or anywhere say, this is the new rule, this is finalized, these are the changes, F1 students can no longer come to the US, any dramatic statements like that, don't fall for those things. These are misconceptions. Always go to the actual government website, read the actual rule. Once it is finalized, talk to an immigration lawyer to see how it will impact you. Don't fall for any other outside third party information.
Yeah, nowadays we see lots of short videos coming up, influencers talking about these things, and this is unnecessarily scaring the students who are more interested in applying or trying to find out their future here.
Absolutely. Just recently, I saw someone talk about how now to file an extension beyond the 4-year period, all students must leave the country and get a new stamp and come back. That is absolutely false. There's nowhere that this has been mentioned, but people are confidently spreading such false information. So F1 students just be aware of that kind of information.
So just for a few clicks and for views, they try to spread so much of widespread unnecessary news that is creating unnecessary confusion.
Yes, exactly.
So, in your professional opinion, what is the single most important thing FN students should understand right now?
I think students need to plan ahead and be prepared. The landscape for F1 students is changing drastically, quickly, and it will impact students who are here in this country already and prospective students who want to come for future studies, right? So keep an eye out for official news sources, understand how that will impact you according to your own long term goals, understand how that may impact your family by either speaking with an actual immigration attorney or your university designated school official, not through all these unofficial sources. And be prepared for the students who are already here. If you have upcoming travel plans, it is important to note that if you leave, Even if you have an I-94 right now for a duration of status, if you leave after this rule is published and come back, you may be given a 994 that is valid only for 4 years or a shorter period of time. So keep this in mind for future travel plans as well. Before traveling and leaving the country, after the rule is finalized, definitely speak with an immigration attorney to see if it could impact your ability to come back, resume your work, stay here, right? So just be prepared. There are so many changes coming up for F1 students.
So, if this rule is finalized, how dramatically could it reshape the international students' journey to the US?
I think quite drastically. I think F1 students are really going to have to think long and hard about whether it's worth it to come to the United States and pursue that dream. If your program and is 2 to 3 years and you might be given 1 year of work authorization, that might be the end of the path for you. That might cut down on all of your other options, including getting an H-1B visa or transitioning to some other long-term visa. That may not be an option for you anymore. So if that is your long-term goal, then F1 students really need to think about whether it's going to happen, and if not, are they willing to go back to their home country and start all over again, right? So I think there is going to be a very drastic reshaping of prospective F1 students and even the students who already live here.
So, are they still allowed to work while they are on F1?
Yes, as of now, the proposed rule does not get rid of OPT or STEM OPT. It only shortens how much time they might be given
Okay.
on work authorization. Yes, that is still very much an option.
For students who are already studying in the US, what immediate actions would you recommend today?
Definitely understanding where you are in your F1 student journey, right? Are you just now starting to study? Have you finished your studies and you're applying for OPT? I think understanding where you are and having a conversation early on with your DSO about how these new rules can impact your ability to finish your studies or get work authorization so that you can be guided accordingly on when and if needed to file a formal extension with USCIS. Know these things so that when you do have to file an extension, you are not shocked. You're very prepared. You have the right paperwork. You have the right support. You have all the documents that you need. I don't want any F1 students to be in a position where they think this doesn't apply to them and then suddenly they find out, oh, I'm going out of status in a month or next week, right? What do I do? You have a job, maybe you have a family here. You have so many things that you can't just suddenly uproot. So have these conversations early with your DSO or an immigration lawyer and think about what the future holds, how to plan accordingly, how to extend your status if needed.
So, in this case, at least those who are on F2, they need to get a job and then have them support the F1 students before they get out of their status. So, can they change into a different visa
The F1
after four
students,
years?
they can, and that is what the 30-day grace period is for. So the what used to
Okay,
be 60-day grace period is being shortened to 30 days. So
right.
in those 30 days, generally the grace period exists so that you can either file and request an extension, you can either continue studying, you can either make plans to depart the country, wrap up all of your things here and leave, or you can request to change your status if you're eligible for any other type of status. So that still will be an option. However, it is not so easy. For example, if you want to change to
Okay.
H-1B, right, you have to
Hmm.
get picked in the lottery. You can't just apply for an
True,
H-1B whenever you feel like it, right? So
true.
your I-94 might end before or after the lottery's done, and you might not have an option to
True.
change. So timing is very crucial, and pre-planning is very important to have a long-term
Mhm.
plan and not just wait and see last minute whether something works out. That might not be an option anymore.
And the H1 lottery is an altogether a different ball game.
Different topic for a different day. Yes. Yes.
True, true. We can dive deep into it again. Yeah,
Yeah.
so whenever, as needed. Okay, so how can universities better support international students through this uncertainty?
I think DSOs, the designated school official for all the universities, every university has an international student services office, right? And there's one person or a team who are known as
Mhm,
DSOs. They
mhm,
I think they can be more supportive even now. They should be proactive and inform students of their obligations, of any deadlines, of any requirements, right? They are there to help students. But unfortunately, the reality is a lot of DSOs are not quite helpful. And unless the student comes with a problem after something has gone wrong, they do not get involved at all. So I would urge the DSOs or the international services offices of all these universities who have international F1 students to send out some emails informing students of key changes that would affect them, to set up
mhm,
appointments with students, make themselves more available, send out give out supporting documentation or letters. So if the USCIS issues a request for evidence or anything, then they can provide
mhm.
letters and support, right? So there's so many ways that universities can be supportive, and they should be now and moving forward to make sure students are maintaining their status. Yeah.
So that was very, very helpful, Ms. Mitra. Thank you so much for all your valuable insights. So, viewers, I hope you're better informed right now of the new rule proposed by the DHS. So, any questions, please feel free to contact Saimithra Reddy or Sakshi TV. We can take it from there. So, thank you so much for your time today. Have a great day.
Thank you so much. Thank you.